The Vice President. Senior Counsel present online and physically. Good afternoon. We welcome you today to the Rnblive, where we are going to discuss Scandalum, Magnatum, Scandalizing the Judiciary as Contempt of Court, Abolished at Home, Alive, and in the Colonies. I request Mr. Philip Karugaba to take on from here.
Thank you very much, and good afternoon, everybody. A warm welcome to you all. Thank you very much for making the time to be here with us to discuss this burning issue. As you all know, the Uganda Law Society is facing a major challenge to its leadership following the president's conviction for contempt and the sentence of 24 months imprisonment. Under our law, a custodial sentence of more than 6 months means that if it's not addressed, there will be automatic disqualification of our president from the membership of the council. We have, over the last 3 or so years, seen a number of custodial sentences for contempt. We've had Ivan Sebaduka sentenced to 36 months by the Supreme Court in 2021. We've had Mr. Malema Bidizi Chwanuka sentenced to 18 months by Honorable Justice Sekana in 2022. We've had Aaron Kiza sentenced to 9 months by the General Court Martial last month. And now we have President Isaac Semakade, 24 months from Justice Sekana. In neighboring Kenya, we saw Wangari Maathai sentenced to 6 months in 1981, Tony Gachoka sentenced to 6 months, 1999, and then we recently saw a total ban on Ahmed Nasir Senior Counsel and his entire law firm from all appearances at the Supreme Court. That was last year. In neighboring Tanzania, we saw Fatma Karume, who was scrapped from the role of advocates for filing submissions that offended the Attorney General at the time. That was in 2019. That conviction was quashed. So today's webinar is about fostering the understanding of our membership of the unique offense of contempt of court. We'll be looking at what is contempt of court, why is it important, what are its forms, what is its current status in England, where we got it from. Is it a necessary limitation on the freedom of expression in a free and democratic society? What are the bounds for fair and reasonable criticism of a judge or a judgment? When do you play the man and when do you play the ball? And when do you get a red card? Then there's social media. Everybody has or can have a platform with potential infinite reach, far beyond a soapbox, standing on a soapbox with a megaphone, or speaking on Radio Uganda. It has turbocharged and mega amplified freedom of expression. When is silence no longer an option for a judicial officer? When is it proper for resort to be had to contempt of court? What is the ideal thickness or hardness of a judicial officer's skin? For the panel to discuss these questions, this issue, we are graced from the Republic of Kenya by 2 senior counsel, both former presidents of the Law Society of Kenya, and I will introduce the other participants individually. We were unable to reach Mr. Mugisha Hashim Mugisha, the applicant who secured the orders for the conviction of the president. We were also unable to reach his counsel. Okay, if you're out there, please, I have an open slot for you, 10 minutes to make your presentation. either for Mr. Mugisha or any of his counsel. I don't recall seeing their names in the record. So as we begin the discussions, I urge all panelists and speakers to be thick-skinned. Okay, this is why we are here, to be thick-skinned or hard-skinned, as was said by Justice Kakuru, may he rest in peace. Okay, and to be tolerant of other views and temperate in your contributions. So now let me turn to our speakers. I'm going to introduce them in the order that they will be speaking. We'll start with Ms. Apio Afra, who is the head of the Rule of Law Committee of the Uganda Law Society. She'll be here to help us set the tone. She'll be here to help us set the tone and tell us where exactly we are and what is going to be happening next. Then the next speaker that we have is Mr. Ahmed Nasir, Senior Counsel. And we are very grateful and honored to have him. Mr. Ahmed Nasir is an advocate of the High Court of Kenya. He joined the bar in March 1993. He's the founding partner of Ahmed Nasir Abdullahi Advocates LLP and is presently the senior most partner at the firm. He's engaged in litigation and he undertakes litigation of high-profile matters on behalf of corporate and individual clients. His expertise and skill in litigation is second to none, and he handles complex constitutional matters, administrative law, judicial review, electoral petitions. He has litigated several landmark cases that have made important contributions to jurisprudence in Kenya, and I will say therefore to East Africa. And he's done this at the High Court, Appellate Court, and Supreme Court. Through his career, he's been involved in precedent-setting landmark cases that has shaped legislative and regulatory frameworks across a range of legal matters in Kenya. He has been involved as lead counsel for the President of the Republic of Kenya in the 2017 election petition at the Supreme Court of Kenya, and he also acted for the Independent Electoral and Boundaries Commission in the Supreme Court election petitions of 2013. And prior to that, he was the lead counsel for the Office of the President in the Waki Commission investigating the 2007-2008 post-election violence in Kenya. He's privileged to be considered as one of the most distinguished, accomplished, and highly regarded legal practitioners in Kenya, having attained the prestigious rank of senior counsel in the year 2012. He's been chairman of the Law Society of Kenya, Commissioner Kenya Law Review Commission, chairman Kenya Anti-Corruption Advisory Board, member of the Judicial Service Commission, publisher of the Nairobi Law Monthly and the Nairobi Business Monthly magazine. He was the co-convener of the Commonwealth Lawyers Conference, Nairobi 2009, and he was inducted into the role of Honors Law Society of Kenya in 2010. He holds a master's degree from Cornell University, diploma in legal practice, Bachelor of Laws, University of Nairobi, and a certificate diploma in international law. Mr. Ahmed Nasir, Senior Counsel, you're welcome. Our next speaker will be Nelson Harvey, Senior Counsel, also former President of the Law Society. Then we will have Mr. Ellison Karuhanga. Should I say who needs no introduction? He's a Ugandan lawyer with Kampala Associated Advocates. He has represented big corporates and high net worth individuals and in both commercial and political cases. We will then have Mr. Benon Makumbi, an advocate of the High Court of Uganda. Thank you. As I said, there's an open microphone, an open slot for Mr. Hashim Mugisha or his counsel. Thank you very much. I will now invite Ms. Afra, the head of Rule of Law, Uganda Law Society, to set the tone for the event. Thank you. Ms. Afra, the floor is yours.
Thank you, Philip. We have a technical glitch. We are kindly requesting you to be patient. We are going to go off for just a minute and then come back. Thank you. Good afternoon. We do apologize for that. I think we're now good to go. Where are we as Uganda Law Society? In Mugisha versus Isaac K. Semakade, HCMA number 59 of 2025, the applicant brought the application seeking a declaration that the respondent acts in contempt of court by publishing derogatory remarks on his social media handle X against the person of the trial judge, Honorable Justice Musa Sekana. The trial judge noted that the respondent's tweets are inappropriate and the respondent ought to be punished. Secondly, that a strong warning or caution should be given to the other foot soldiers. He ordered for the arrest and imprisonment of the ULS president for a period of 2 years. The ULS Executive Council and members of the society are pushing for an engagement with the Honorable Chief Justice to discuss court baton issues concerning the relationship between the bar and the bench, among others. What is happening next? The ULS president has instructed senior advocate Mr. Peter Walubiri of KBW Advocates as the lead lawyer in this case, who shall be challenging the arrest warrant on several grounds, including Justice Musa Sekana's failure to apply the natural justice principle of memo judex in causa sua, which means that no one should be a judge in his own cause. This raises questions about the impartiality of the judiciary, which erodes public trust, yet public confidence in the judiciary must be preserved at all times. A team of lawyers have also been appointed as a think tank to strategically handle the litigation of this case. A litigation strategy is being agreed upon, and the team will disclose the interventions agreed upon in the coming days. On contempt of court, while benchmarking several jurisdictions, you find that contempt of court is provided for under legislation. For example, the UK Contempt of Court Act of 1981, India's Contempt of Court Act of 1971, Kenya's Contempt of Court Act 8F of 2017, Zambia's Contempt of Court Miscellaneous Provisions Act of 1965, among others. Therefore, there is a gap in our legal system that is being constantly abused and needs to be addressed. I thank you for your kind attention.
Thank you very, very much. Thank you very, very much, Afra. You have set the tone very well. You've outlined to us where we are and what we are facing. You've also set a record for the time limit. Thank you. So our next speaker will be Mr. Ahmed Nasir, Senior Counsel. As we said, he has been the subject of a ban by the Supreme Court of Kenya, not only him, but his entire law firm. Okay, we would like to hear from him what we can learn from him about what we are facing. Mr. Ahmed Nasir, I didn't mention Grand Mullah in your titles. It was not in the brief I got. Let me include it now. Over to you, sir. Mr. Ahmed Nasir. Do I see you? Yes, your microphone.
Yes.
Thank you. 10 minutes.
Or I didn't join you. Is it my time?
Yes.
Do I talk about the topic?
And your experience. Would like to hear your experience.
Yes. Thank you, Philip. Good to see you again. We met in Kampala last time, and we have a slight history of meeting many years ago. I think this is a very, very topical issue in light of what's happening in Uganda, and one of the few things that happened in Kenya. But I think, this topic is, although it has a history of the background is common law history, we need, to contextualize. And because as lawyers, law always must be interpreted in context. I mean, there's a polarity of normative, competing normative values in this debate. And I think in order to contextualize, the origin of scandalizing the court, from England, how we transplanted it into Kenya. I mean, I would just like to remind our participants and everybody who's listening to us and debating, of the famous case of Nyali Limited versus Attorney General, where Justice Denning, compared the English common law to the English oak. And he says, you don't just transplant the English common law to Africa and expect it to have, the same, I think he said the same rigor, the same strength, and all those things. He said, of course, it will flourish, but it has to adapt to the terrain of Africa. And I think that is, when we are discussing, when we discuss the law on contempt of court or scandalizing the court, and, I have read this judgment of Justice Musa Sakena, where, he is talking about, contempt of court, scandalizing the court in the context of an English court. And I think that's what I always tell when I talk about these issues. That's what I always tell them. We must never forget the context. I mean, when the English court defends an English court, I think it makes a lot of sense. I mean, that's a court of integrity. That's a court of certain standing. That's a court that has been there for the last 700-800 years ago. It has gone through all process and evolution. So when the Kenyan court or a Uganda court or a Tanzanian court cites those dictums from the English court to defend itself, I think the first thing we have to appreciate is that the courts are out of context. those dictums, those issues that say that, you are scandalizing the court, you are bringing the court into disrepute, you are lowering the court in the eyes of ordinary Kenyans. It applies to an English court. You have to understand what is the status of a Ugandan court or a Kenyan court or a Tanzanian court in the eyes of an ordinary Kenyan or an ordinary Ugandan or an ordinary Tanzanian. And I think I am speaking the truth when I say that the average Ugandan, the average Kenyan, and the average Tanzanian see their courts as the den of corruption. It is a den of corruption. I mean, nobody, the ordinary average East African does not have faith in his court. So when the court would say that, you are lowering the dignity or the standing of the court in the eyes of the ordinary Kenyan, I mean, they are transplanting the English setting into a factual setting that does not exist empirically. I mean, nobody has a respect for a Kenyan court today. Nobody has a respect for Ugandan court. Nobody has a respect. So when, for example, the chairman of the Ugandan Law Society spoke the way he spoke, I mean, that is the truth. That's what I say every day. But at least a Kenyan court, I mean, the Kenyan court, unlike the Ugandan court, probably they are realists. They know the reality. When we tell a Kenyan court that the court is corrupt, they know they are corrupt, so they can't charge it with contempt. And just to correct my friend Philip, when he was saying that when we were banned, for example, in the Supreme Court of Kenya, I mean, we were not we were not tried for contempt. We were not cited for contempt. Because the court knows that if they cite us for contempt, we will have our day in court. We will bring the evidence we say in relation to the court. We will be able to prove that the court does not have a standing that needs protection. I mean, the court has no standing. It's what I call jurisprudential courts. So I think as we debate this issue, we have to contextualize this common law case law on contempt of court and scandalizing the court, and make the distinction that the normative values that inform the development of that jurisprudence in England does not apply to the context of East Africa, because the East African courts are corrupted to the core. The East African courts are under the thumb of the executive, and the few countries where, scandalizing the court, contempt of court still exists are in Far Asia, places like Singapore or places like Hong Kong, where the democratic space is limited. When the democratic space is limited, the government uses the offense of contempt of court or scandalizing the court to suppress the democratic freedom of the country. And I can tell you for one thing, and I think Ugandans, we have been there because we're slightly more advanced than you on certain things. But you have to understand that in the context of East Africa, the courts are part of the executive. I mean, at least that was the case in Kenya in the 80s and 90s. Now they are no longer part of the executive. We have cut that empirical cord between the two. But Uganda may be different, Tanzania may be different, and other countries may be different. But I would like just to emphasize the point that if you see a country where the courts enforce the offense of contempt of court or scandalizing the court, it is part of the broader political tussle in the country. And the judiciary is playing the agent of the state in suppressing the right of the people to express. So I can tell you for free that when you read the judgment of Justice Musa Sakena, you must read in the context of the debate that's going in Uganda. The chairman of the Law Society of Uganda is being suppressed. The judiciary, the Ugandan judiciary as the agent of the executive, wants to stop one of the most vocal voices in the country from speaking for the people of Uganda. So don't just see it as a case where, one court trying to stop the chairman of the Law Society. I mean, you have to see it in the broader context of what is happening in a given country. And scandalizing the court, contempt of court is a powerful tool used by the executive via the judiciary to suppress freedom of expression. I mean, luckily for us in Kenya, I mean, Harvey will, I'm sure, support me this. I mean, it is inconceivable. It is inconceivable for any court in Kenya to hold the chairman of the Law Society in contempt, because that is impossible. They tried many years ago, I think in early 90s, when Paul Mutte was the chairman of Law Society, but they did it again because the executive told them. But in Kenya, it's inconceivable because we are past that stage. Although the offense of scandalising the court, common law is still there, it is not possible for a Kenyan court to hold a person of the stature of our chairman or a president of the court, or even for that matter, any lawyer. But finally, I think I will just repeat this point. This offense cannot apply to East African courts because this offense, even in England, I think, where it's no longer part of their laws because it has been repealed statutorily. The East African courts are corrupt. The East African courts are inefficient. The East African people are pro-government against the people. And the issue of scandalizing the courts does not arise because they don't have the gravitas. They are not on a pedestal that needs protection. They are not on a standing that needs protection. So when I tell a court in Kenya that the court is corrupt, I mean, the court obviously knows it's corrupt. It will have nothing to say, probably concur without saying it. So I think we need to contextualize this issue, and as members of the bar, we need to protect freedom of speech and put the judiciary in its place, because the judiciary really is not protecting itself like when Justice Musa Sagana gave that ruling. The judiciary is speaking for the executive. I mean, we don't have to be naive to think, for one, is that the honorable judge is protecting the court. The honorable judge is protecting the political status quo. And one of the most important institutions in these regions are the law societies. And the law society must ensure that this democratic space is protected, freedom of expression is protected, and the judiciary, which actually I've said this many times when I write about the Kenyan judiciary, especially in the historical context, the Kenyan judiciary was at the forefront of defending the Moi state. It was a very powerful organ that defended the freedom, that defended the Moi state. It was a very powerful organ that tried to limit, the constitutional reforms that was going in Kenya. And I'm not surprised that, Sakena Musa judge gave the ruling he gave when he ordered the chairman of the law society to be imprisoned for 2 years. But I think in conclusion, bottom line I'm saying is that the Ugandan courts, the Kenyan courts, and even some East African courts do not have the stature that needs protection through this common law. They have no integrity, they have no standing, they have no legitimacy, they are not pro-people, they are anti-people. So when they say that, you are lowering in the eyes of the common man has a bad view about these courts. So the common man actually will concur with the sentiments, of your chairman and many people of similar view. I think that's what Justice Sakana calls foot soldiers. I mean, foot soldiers are the people of Uganda, I'm sure, in this case. Thank you very much, Philip.
Yes, thank you very much. Thank you very much, Mr. Ahmed Nasir, Senior Counsel. Thank you very much for that rapid fire presentation. Thank you very much for emphasis on context. On context. It was a big point of departure between myself and the last president of the Law Society, context. And I think you put it very well for me in this setting. Thank you too for the clarification you have made that in your Supreme Court ban, it was not a citation for contempt, but rather a unilateral move by the court to exclude you from you and your law firm and all the lawyers in it from appearances. But before I let you go, Mr. Ahmed Nasir, I would like to ask, you've read the ruling of Justice Sekana. You have seen the language that is said to be contemptuous. How would a Kenyan court react in the face of social media posts with such language?
I mean, first, I think let me be fair. I mean, the Kenyan courts are much different than Ugandan courts. I think your constitution comes a little bit earlier than ours, came a little bit late. I mean, you have different history in terms of how constitutional making process was done. Our constitution is very robust. You know, the 2010 constitution is robust. We have a fairly independent judiciary in terms of, I mean, the Kenyan judiciary is independent from the executive, but they are not independent from, you know, the bribe giver or the, yes. So they are not free from ordinary people who gives them bribe, but they are not, they are independent from the executive that tries to control. Because unlike you, we are the only country in the world where the president has no say in the appointment of any judge or judicial officers. Right from the Supreme Court up to the magistrate, I mean, it's the Judicial Service Commission that appoints. I think we are the only country in the world where the Chief Justice is appointed without the president having any idea, or the Supreme Court judge. I mean, I have seen some of the tweets. I mean, some of them are, I mean, they don't raise much about for me. I mean, if you look at paragraph, I think, is it page, I think page 3, or even page 2, where he says we're investigating serious allegation of possible unholy alliance. I mean, that's not contemptuous. That's freedom of expression. I mean, the chairman of the Law Society, I don't think did anything, you know, that is scandalous to the court. The other one, I think, similarly doesn't. There's only one which when I read, I laughed hard because. But that one, I think, probably it is because I called someone to say that has the judge been accused of, you know, this kind of harassment? Probably the chairman of Law Society has information that we don't have. Probably the chairman. I mean, when you are chairman of Law Society, so many of your members bring you to complain. So if there are complaints of this nature that came from, you know, the female members of the society about the judge or about X or Y, probably he has information. But I think, I mean, that one, I mean, that's the only tweet, you know, I felt a little bit was below the belt. But again, I will excuse it because maybe that is, I mean, that's probably what his members have told him. I mean, you see, the chairman of a law society is a very representative of a broad spectrum of people, and there are different people who tell him different things. If the judge is a judge, and I'm not saying that, I mean, I think respectfully, I will not say much about this, but I think generally the other tweets were basically comments about, you know, the judicial politics, what's happening in the courts, what's happening in the politics of Uganda. And, you know, judges should be thick-skinned, you know. I mean, there will be a lot of commentaries there. I mean, we talk a lot about Kenya here, but we talk very forcefully about the decisions of the court or what they do. And the Kenyan courts, you know, take these things in their stride. Once in a while, the Chief Justice may, you know, put a paragraph in her judgment complaining about this. But, you know, most of them, take it from me, it's only a very insecure judge, a judge who is very insecure, a judge who had so much baggage, a judge who is afraid of scrutiny. Those are the judges who complain. Those are the judges who complain. Many judges don't complain about, you know, the comments we make about the Kenyan judiciary or you know, the allegations of corruption, incompetence. They don't complain because it is too general. Kenya is a country where we have a very robust discussions. But when you see a judge complain, I mean, the judge who cited your chairman in maybe, I don't know him, but he comes across as a very insecure judge. And I think the same applies to your Chief Justice. When I saw him commenting and refusing your chairman to represent, I mean, that's a very insecure Chief Justice. I mean, what is wrong with the chairman of the Law Society expressing his view in a public forum? I mean, we do a lot of things here. We criticize our president. We say so many things, but the political class in this country hold their fort. They hold their ground. They can reply back. But when you see, and I think this judgment probably, I'm not speculating, but this judgment is probably informed by the sentiments expressed by the Chief Justice of Uganda when he stopped your president from giving. It was the green light, you know. It was a dog whistle for judges to act against the Law Society. And I think as a society, you know, you should not allow this. You should not allow, whether it's the Chief Justice or other courts, you know. to oppress, to muzzle, to scuttle, very important institutions like the law society. Law societies in this region speak for the people. Law societies in this region are very important players, even in the politics of the country, in the democratization, in the constitutional adherence of norms. So I think this judge should be rightly called for, and the Law Society of Uganda should continue this agitation against him.
Thank you very much, Senior Counsel. Thank you very much for that explanation. And you're helping us chart the bounds of fair and reasonable commentary. And you're saying that the Kenyan experience is much more robust. The officials are much more robust. But you've said something very, very important about a tweet which you say is below the belt. So I think we can put a marker there and say reasonable and fair criticism don't reach below the belt. Maybe we should say below the waist, so that we can capture both ladies and gentlemen. Thank you very, very much, Senior Counsel. Please hold it there.
Finally, before I go, let me just add one report. Yes. I mean, there's this contempt case you cited of David McCauley, and I think it was it in the 90s or yes, by the. Yes. I mean. The judges who are involved in that, I mean, that was a very important issue on two occasions. One, when we had the new constitution and those judges applied to become judges of the Supreme Court, I was in the Judicial Service Commission that interviewed them. And for us, that was a very important issue. We asked the judges, I mean, how could you hold people in contempt for expressing their view? And that, formed a very important factor on whether they could join the Supreme Court or not. And I can tell you, it played a very pivotal role. And we said that, someone who can muzzle either a lawyer or a politician from expressing their views is not right material for the Supreme Court. Secondly, I mean, when we had the 2010 constitution, we had what we call the vetting of judges and magistrates. And again, those same judges were, when they went before the vetting committee, which comprised of, outstanding judges from Africa and throughout the world, some of them were told, how could you justify ruling, or how could you justify making those judgments? And it is because of that, among others, that they were removed from the judiciary. So these judges of yours, they should learn a lot from Kenya. These decisions they make may come to haunt them tomorrow. I mean, I don't know how effective your JC is, but in our JC, probably a judge like Justice Musa Sakana will never go to the next level in light of this decision, because the Law Society of Kenya has very strong representative in the Judicial Service Commission. And if you make a decision like this, you will not get promoted in Kenya.
Thank you very much. Thank you. I just forgot to pick up on one point when you said that the Kenyan president has got no role in appointing judges. I just wanted to say, in Uganda, we have a judiciary that has all been appointed by the same president. But now I'm going to move on to the next speaker, who is Mr. Nelson Harvey, Senior Counsel and former President of the Law Society of Kenya. Welcome, Mr. Harvey.
Okay, thank you, Philip. It's a pleasure seeing you again. I acknowledge the presence of senior counsel present, members of the Radical Bar, and members of the Brave New Bar. Philip, after you have unleashed the Grand Mullah, and then thereafter you follow with another arsenal in the name of Harvey, the debate is going to be hot. But anyway, let me pick up from where Rnblive Senior Counsel has left. I once had a chat with the former Attorney General and one of the most distinguished presidents of the Law Society. In actual fact, the first Black president of the Law Society of Kenya, Amos Wako. He told me that upon his appointment he sought audience with the Chief Justice, then Sir James Weeks, and asked that African of Kenyan origin be appointed to the bench. And this is what Sir James Weeks told him, that an African is inherently corrupt and impartial to be an objective judge. I mean, it would be a big shame 40 years later for us to prove Sir James Weeks right. But to a large extent, that's where we are. Because how else do you explain the decision by, I don't know what is his name, let me call him Judge Musa, to convict and sentence President Isaac to jail for 2 years. I've read that decision. The judge does not cite any legislation, let alone recent law, to justify his action. In fact, he goes and dwells upon at length on obsolete, defunct English decisions that criminalize what we can call, quote unquote, scandalization of the court. He makes this decision notwithstanding that even in England itself, the offense of scandalizing the court was repealed and is no longer there. Let us look at the case of Tanzania. Although it was not at the initiative of the judge, as it appears from the face of it, we all know it was at the initiative of a particular judge. And sorry to say, for this case, it was at the initiative of the then president of the Republic of Tanzania. It has happened before here in Kenya, as Ahmed has alluded to it before, with the case of Professor Wangari Maathai and Tony Gashoka. I had a chat before we started this webinar, and Paul Mwite, who then represented Professor Wangari Maathai, gave me a very candid disclosure on this matter, which we can have a discussion with you outside these parameters, because it may border on what we may be accused of adopting the same language as my friend in Uganda, President Isaac. But anyway, when all is said and done, Wangari Maathai was compelled by Justice Simpson to write an apology of her choice. So she wrote an apology of her choice, and she ended up serving 2 days and was released. But fundamentally, there are certain things that we must underscore. Kenya has the benefit of having gone ahead of Tanzania and Uganda. We have a judiciary. I doubt whether we have a judiciary in Tanzania and in Uganda. I will be allowed to say that in Uganda and Tanzania, we still have a judicature, a symbolic court, a symbolic judicial system where the active player is actually the executive. Distinguish that with Kenya, where you'll see an attempt to take us back to 1979, a point in time where Justice James Weeks lamented the objectivity and impartiality of an African judge. Why do I say so? When delivering the judgment of the BBI matter, the judges of the Supreme Court purported to convict Ahmed Nasri, myself, and another advocate of contempt of court. Nowhere did they cite any enabling law for their action. In fact, they made a weak-kneed attempt to refer to the Advocates Act. Yet even the Advocates Act itself requires that any such a conviction be made by the Advocates Tribunal. Did they stop there? Within 2 weeks, the Chief Justice Martha Koome enacted a regulation barring debates on any matter pending before the Supreme Court. Remember, even the Supreme Court Act itself does not enable her to make these regulations. As they succeed tonight, those regulations were found to be unconstitutional and declared null and void. Now, unknown to us, and Ahmed, this is something that we may need to take up, it will appear that whereas we are challenging the rules that were enacted, the Chief Justice and her other 6 judges had sneaked an amendment on the substantive act, with the result that we have Section 28 of the Supreme Court Act, reading that court has the power to deny audience to anybody that it has found in contempt of the court. But even then, that power enables the Supreme Court to meet this sentence for a period not exceeding 18 months. Let me now go back to this ruling that was eventually given by the Supreme Court upon discovery of the mistake that the court had made, having previously issued a directive barring Ahmed and his associates from appearing before it. So the court sat and decided to write a ruling purporting to recuse itself from hearing any matter where Ahmed and or his partners and associates appear before it. Yet in actual fact, that is not a recusal. And any student reading this ruling will realize that nowhere again has the court stated any legislation, let alone case law, that empowers it to take this particular action. I don't know how much time had been given Philip, but I will summarize, and then thereafter we can have a discussion. It is my premise that scandalizing the court as a facet of the contempt of court is no longer available here in Kenya. Why do I say so? I say so because the power to punish for contempt of court was given to the Kenyan judiciary through the Judicature Act. Now, the Judicature Act enabled courts in Kenya to punish for contempt in the same manner as any other English court would have done. The Judicature Act, insofar as it contained that section, was amended and repealed and replaced with the Law of Contempt of Court Act. Again, the Law of Contempt of Court Act has been declared unconstitutional for, amongst others, want of public participation and interference with the independence of the judiciary. I think Justice Chacha Mwita meant this when he said interference with the independence of the judiciary. And he's one of those judges, I would say, is an exception to the general rule by Sir James Wicks. It is not upon the judiciary, it's not upon the court to start litigating as a claimant against an advocate who is appearing before it. And there is merit in that premise in law. So after that Contempt of Court Act was declared unconstitutional, we can affirmatively say that Kenya is in the same position as England and Wales insofar as the offense of contempt, in particular, scandalizing of the court, is concerned. We do not have that offense in Kenya. And look, friends, you from Tanzania and Uganda must realize one thing. The gains so far made in Kenya were as a result of the determined effort of lawyers. In fact, I can tell you without any fear of contradiction, with the Constitution of Kenya, the status of governance as it is right now, forget about this late entrant who stole the Constitution. The Constitution of Kenya is a product of the Law Society of Kenya throughout the period. And that's the reason why, no matter how boldly we speak, no matter how offensive Martha Koome may perceive what Ahmed Nasser and I say, she will not dare jail us because it will not happen. Why are you allowing this to happen in Tanzania and Uganda? You must say no. And this is what we've done here insofar as taking remedial action against these judges who are inherently impartial and corrupt. We have removed them from office of judge. Justice Riaga Omolo, the remnant in the bench that convicted Tony Gashoka, was declared unsuitable to continue holding office solely for that purpose. Justice Mary Angawa, who had the audacity of jailing an advocate, was removed from office substantially on account of that ground. So this is what you must do to remedy the unconstitutional and unlawful action taken against President Isaac Semakade. Initiate the removal of that judge from office. If you can't do it through the Judicial Service Commission, remove the judge from the role of advocates in Uganda. At least it will be a step toward the right direction. In conclusion, therefore, it is incumbent upon us, Uganda, Tanzania, and Kenya, the founder members of the East African Law Society, to be firm to ensure that the freedom of expression, in particular, the right of an advocate to express himself or herself, is never curtailed. Not today, not yesterday, not tomorrow. Thank you, Philip.
Thank you very much, Mr. Harvey, Senior Counsel. Thank you very much for that excellent submission, building on to what we had from Mr. Nasir, Senior Counsel. And your ending call is that we, as the founders of the East African community, be firm on the freedom of expression, especially as it applies to advocates. Thank you very much. Thank you. I am hearing that there are lots of questions in the chat box. I think this dinosaur doesn't know what the chat box is. I cannot see questions. I see lots of hello comrades and hi comrade and great submission and compliments. Thank you. If that's the chat box, please put in the questions. I promise to find them. Thank you very much. Mr. Harvey, so the bottom line is that Kenya has moved on. You are past this stage of Scandalum Magnatum. You are at the level of England and Wales, where that offense does not exist anymore. And the question is, in Uganda, where is its legal foundation? Thank you very much. Okay, so for the next speaker, I would like to call on Mr. Ellison Karuhanga. Ellison, are you there? Ellison? Ellison?
Good evening.
Thank you.
Or good afternoon. I am making this address from ULS House. I thought we were going to all be here. I was looking forward to meeting Mr. Ahmed Nasir and Mr. Nelson Harvey. But I've only met my good friend, the Vice President of the Uganda Law Society, which is, I think, a fair improvement. I am going to make a presentation about this very complex and interesting issue. So, first of all, I thank you, Philip, for allowing us to be here. Colleagues and learned friends, we are gathered today, in my opinion, not to question the authority of our courts, but to affirm the principle that justice is strongest when justice is just. We are here to affirm the principle that we must respect the courtroom, and the wisdoms of the rulings in the courtroom stand taller than the demands and threats that come from there. Contempt of court is an ancient doctrine. It exists to protect our courts from disorder, to ensure that the decisions of our courts are enforced, and to preserve the solemn process of justice. A court without the power to enforce its orders is a court without authority. A legal system in which trials are disrupted without consequence is a legal system in which justice is perverted. But today we ask a deeper question. Does contempt of court serve the rule of law, or does it sometimes undermine the rule of law? In my view, while we can't talk about protecting the courts from chaos and protecting justice in being done, we must make sure that contempt is safeguarding trials from obstruction and preserving the fairness of the legal process. It must not be wielded as a shield against critics or a tool not to uphold justice, but to silence those who demand it. And so I'm honored to be discussing this topic of scandalizing the judiciary. Of course, I am also humbled that I am discussing it after some of East Africa's most prominent and well-known lawyers. There's an issue here in Uganda, what we call colonial laws. People tell you something is colonial. And so the first question we must ask ourselves is contempt of court a colonial law? And even before you answer that, you must ask yourself the question, what on earth is a colonial law? In my view, a colonial law is not an old law. Mr. Ahmed Nasir, in his presentation, told us what people think of the court in England. But in my view, it is not an old law. It is not a law passed by our former colonial rulers. A colonial law, in my understanding of the term, is a law imposed not to serve justice, but to serve domination, designed to sustain the control of foreigners and to suppress the dissent of natives. Colonialism was not just about administration, it was about, and it was not even just about control. It was about shaping a system in which those who are governed believed that they had no right to question those who governed them. And it took on many forms, slavery and all that history. Dr. Martin Luther King, in his book, Chaos or Community, Where Do We Go From Here?, described the impact of this system. And he said, and I quote, "The job of arousing manhood within a people that have been fought, that have been taught for so many centuries that they are nobody is not easy. Even semantics have conspired to make that which is black, ugly, and degrading. In the thesaurus, there are 120 synonyms for blackness, and 60 of them are offensive: blot, soot, devil, foul. A white lie is better than a black lie. The most degenerate member of a family is the black sheep and not the white sheep." Thank you. I've been given serious technical assistance. So, colonialism wasn't just about taking land, or it was really about taking dignity. And the constitutions that we have in our region are constitutions written to restore dignity. Article 126 of the Ugandan Constitution declares that judicial authority must be exercised in accordance with the wishes of the people. Article 274 of the Constitution demands that all law must be brought within conformity to the Constitution. So let's go back to our question. Does contempt, as it exists today, serve the people, or does it serve what you would call the colonial interest? And I'll very briefly go to say that there are two kinds of contempt: civil and criminal. One meant to uphold the law, and the other meant to punish defiance. Civil contempt arises when you willfully disobey a court order. It's not punitive, it's remedial. The purpose is not to punish, but to compel compliance. If a court orders you to do something and you do not do it, you are found in civil contempt. The punishment in such cases, whether fine or imprisonment, exists only to enforce obedience. A person in civil contempt holds the keys to their own prison. They purge their contempt at any time by complying with the court order they have disobeyed. So it is not about protecting the pride of the judge, but ensuring justice is done. Criminal contempt is different. It's about enforcing court orders and punishing those who challenge court's authority. So if you stand up and disrupt court proceedings, try to make it impossible for the court to proceed, act in a way that is openly defiant to the court, you can be cited for criminal contempt. And the purpose is to simply punish you. Without criminal contempt, trials would be turned into spectacles, judicial orders would be mocked without consequence, and the very concept of a fair and legal process would collapse. But we are not talking about that today. The branch we are talking about is not to protect the court from disruption or to prevent the obstruction of justice. It is about It's not even about preserving the rule of law. It's about silencing those who question the court. The idea of scandalizing the judiciary, which comes under the head of criminal contempt. The leading case on this in Uganda is a Supreme Court case of Sabaduka, where the Supreme Court held that any affront on judges who are indeed handmaidens of justice is in fact an affront to the people in whom judicial power vests. Any insult, as this one, directed at the justices of this court, or at any judicial officer for that matter, amounts to contempt. I think Mr. Sabaduka had referred to their lordships as a council of fools. In another case, a High Court case of Malema is citing the Sabaduka case, the court held that scandalous attacks upon judges are punishable, upon the principle that they are against the public, not the judge, an obstruction to public justice. So the idea is that on top of just frustrating the court, insulting it as well can be found to be contempt. Now, I don't necessarily share the fire in the belly approach of the senior counsel, Ahmed Nasir, who says that our judges are not deserving of respect. I take the opposite view, that their lordships should be respected. And so I am not here to make a case for us to insult their lordships. The question is the doctrine a just doctrine? Now, and let's go back now to the first question. Is it colonial? In my view, the actual concept of contempt is not colonial. But is the concept of scandalizing the judiciary colonial in the sense of demeaning the people of the colonies? Unfortunately, colleagues, and very respectfully, I will answer this question in the affirmative. In England, the highest court until a few years ago used to, I think until 2007, used to be the House of Lords. And when handling matters from the colonies, the Judicial Committee of the House of Lords sat as what was called the Privy Council. So for English law, for courts in England, the appeals would go all the way to the House of Lords. And for courts in the colonies, the appeals would go to the Privy Council. And although the offense existed and had its history in England, the English courts decided a long time ago to stop using that principle. It had become obsolete. And in the case of MacLeod versus St. Alban, an 1899 case, the British Privy Council said that that law has become, quote, obsolete in England. And I want to quote now what they said. Committals for contempt of court by scandalizing the court itself have become obsolete in this country. But it must be considered that in small colonies consisting principally of colored populations, the enforcement in proper cases of committal for contempt of court for attacks on the court may be absolutely necessary to preserve in such a community the dignity of justice. Put simply, this law was to be kept for colored populations. To that extent, it does have its history in colonial times. And as recently as 1999, the same English Privy Council, citing this same authority, found the need to apply that same principle in Mauritius. And I think some of the Ugandan cases have actually quoted some of these Mauritius decisions. So it does, unfortunately, have a base in the idea of the wrong form of colonialism. But I want to also, again, picking up from my colleagues who spoke before, I want us to look at what is the legal landscape with regard to this sort of thing in Uganda. The Penal Code used to have Section 39, which says that a seditious intention, which outlawed what was called sedition, and says that a seditious intention shall be an intention, A, to bring into hatred or contempt, or to excite disaffection against the person of the president, the government as by law established, or the constitution. It also provided that any speech shall be deemed to be seditious, unless by reason only that it intends. Anyway, I don't have to go into that. And then it had a punishment. So we had a law in this country saying you cannot have speech, the purpose of which is to bring into hatred, ridicule, and contempt the person of the president. And indeed, a famous journalist, Mr. Mwenda, was once cited for violating that offense when, by his own admission, he made comments and the very next day found his own comments to have been quite extreme and apologized for them. He was then arrested and charged with the offense of sedition, and he challenged that offense in the Constitutional Court. The Constitutional Court found that the offense was so wide, and I'm starting to wind up. Our people, but they said this, and I want to quote this part of the Constitutional Court decision in the case of Andrew Mwenda. Our people express their thoughts differently, depending on the environment of their birth, upbringing, and education. While a child brought up in an elite and God-fearing society may know how to address a leader politely, his counterpart brought up in a slum may make annoying and impolite comments, honestly believing that that is how to express himself or herself. All these different categories of people in our society enjoy equal rights under the Constitution and the law, and they have equal political power of one vote each. They can be very annoying and character assassinating remarks, and yet in most cases false. The reason is because they have a right to criticize their leaders rightly or wrongly. Leaders should grow hard skins to bear. We find that the way the impugned sections were worded have an endless catchment area to the extent that it infringes the rights enshrined in Article 29, freedom of expression. We answer that question in favor of the petitioners. The court therefore struck down the law of sedition on the ground that a statement made to annoy the person of the president is okay. In the case of Onyango Bo and Andrew Mwenda, the court found that a false story, an allegation had been made that false news had been published again against the president. And the court said that in a free and democratic society, it is almost too obvious to need stating that those who hold office in government, who are responsible for public administration, must always be open to criticism. Any attempt to stifle such criticism amounts to censorship of the most insidious and objectionable kind. And the court found that actually you could spread false news, and that the right in Article 29 is not limited to those who are telling the truth. Even liars are afforded that protection. Onyango Bo and Andrew Mwenda preceded social media and the internet. And social media has been a remarkable force for democracy, for catching up with things, and for turning the world on its head. It's given a platform to the unheard. But to many, social media has amplified the worst tendencies in modern society. Scandal and controversy dominate social media. Sensationalism generates more engagement than balance. Attacking people is more powerful than attacking people's motives is more powerful than criticizing people's judgments. If someone is wrong, it is not enough for you to say he is wrong. You must say he's stupid, he's evil, he's satanic. Yet the guy is just wrong. And social media has nuance sometimes is lost. As a result of that, the Ugandan leadership enacted the Computer Misuse Act, the purpose of which was to outlaw offensive communication. So post Onyango Bo, we now had offensive communication laws. And again, in Andrew Karamaji versus the Attorney General, the section, I believe it was 25, was taken again back to the Constitutional Court to see if it is constitutional. And the court said that in a democratic society, prosecuting people for the content of their communication is a violation that falls within the guarantees of freedom of expression. They cite a European case and they observe that freedom of expression includes the right to say things that offend, shock, or disturb. The court concluded that it would not be appropriate to prosecute in such cases. The impugned section is unjustifiable as it curtails the freedom of speech in a free and democratic society. Section 25 of the Computer Misuse Act does not specify even what constitutes offensive communication. So, colleagues, each of these laws had their basis and their justification. The purpose of these laws was to protect leaders in the conduct of their work from being unnecessarily scandalized. And the judiciary has removed that protection from the executive and the legislature. And now the question must be asked. Why then do we need that protection for their lordships, since they have consistently felt that that protection is not needed for Parliament or the President? Is demanding such protection safeguarding justice? I am not sure. In saying this, we are not calling for people, and in holding the way they held, the Supreme Court was not calling to unleash an avalanche of abuse on the President or anyone else. And in speaking here today, I am not speaking as somebody amused or impressed or excited by abuse. But what we are saying is the law must be the same thing for everyone or nothing for all of us. What we are saying is that I heard my colleagues from Kenya saying that in Uganda our jurisprudence is not well developed. In fact, our jurisprudence, I want to submit, is extremely well developed. I want to submit that our judicial officers are extremely good. That is why even now, at the worst stage between the judiciary and the bar, lawyers, I'm seeing my colleague here, lawyers are filing matters against judges before judges. The Ugandan judiciary has always stood on the side of expanding access to justice, of expanding communication, and of stretching the principles. If it was right for Andrew Mwenda, it must be right for others. And that is the argument. The other point I want to make very quickly is very quickly, yes. One of the big dangers, of course, is the due process requirements. If the law of sedition exists and you are accused of telling lies, or the law of false news, and you are accused of telling lies, you can be arrested, taken to a police station, record a statement, arraigned before a court, and have your day. Lead the evidence, take a plea, if found guilty, beg for mercy. Why, of all the offenses, by the Constitution allowing contempt of court, did it overturn the right to a fair hearing before an independent and impartial tribunal? When I last read our Constitution, it said that that right is sacrosanct, non-derogable. So I want to conclude like this. On the big issues I had, and I'm happy that the Law Society has told us that they seek to engage with the judiciary. And I think that engagement is necessary and it is important. Because what affects the bar directly affects the judiciary directly. We are Siamese twins joined at the hip. We are the only profession for which an arm of government has been set aside. Their lordships, while they are masters of the courts, we are the court's officers. And so I'm happy that the Law Society is thinking of finding a way to approach and make peace. But as we go on the issues of the doctrine of scandalizing the court, I will submit very respectfully that while I disagree with my brothers that Ugandan judges are for abusing, I think Ugandan judges, from their record, are judges we should respect. I will submit that their lordships earn a lot more if the respect they are getting is the respect of the decisions they are making and not fear of contempt. Lastly, the biggest danger with starting to cite lawyers in contempt is now, while you can insult, and you shouldn't insult, by the just don't insult people, but while you can insult, everyone walking, even the chief magistrate now is going to start throwing lawyers who appear before them, is going to start citing them for contempt. So we need to find a solution that is amicable, but at the same time, it is my humble submission that our courts are not, Ahmed Nasir said we are not like London, that our courts are like Ugandan courts. They are to be respected in the finest tradition of Uganda. Now, Philip is asking me to stop, but he knows that I'm running for an election on the Judicial Service Commission, and it is my intention to speak and speak and speak until people agree with me. But with those few words, allow me, colleagues, to thank you. I want to thank you, Philip, and to thank everybody who has listened. Much obliged.
Thank you very much. Thank you very much, Mr. Ellison Karuhanga. I know there's a button here that sends funny images across the screen. Members online, if you could find that thing and press it and show your appreciation for what you're hearing. Thank you, Ellison. The law must be the same for all or for nothing. You've pointed out that the judiciary disrobed the executive and the legislature of protection on insult crimes, but they have kept that protection from insult for themselves, which you say is not the right approach. You also cited 2 cases, McLeod, which I'm asking you to share with the Secretariat so we can add it to the list of authorities that we gave the membership before starting this call. You also mentioned something about purging the contempt, and I will come back to you about the importance of purging the contempt. Does it mean therefore that a conviction for contempt is not appealable in the ordinary sense that we know it, absent a purging of contempt? Thank you very much. Our last speaker on my list is Mr. Benon Makumbi, an advocate of the High Court of Uganda. You have 10 minutes. So we allowed the audience some time. Thank you very much. Thank you very much.
Thank you very much, Philip. Can you hear me?
Loud and clear.
Yes. I'll start my presentation by stating that protection of the judiciary from insult, or what we call the offense of scandalizing the court, is not compatible with our constitutional values, especially in regard to judicial accountability. In the context of what happened in this matter, I'll go straight to page 9 of the ruling. The ruling in Mugisha Hashim Mugisha versus Isaac Semakade, High Court Senior Certification number 99 of 2025. The trial judge in that application was very clear that criticizing the court and pleading mere criticism is also liable to punishment. And then he goes ahead to state that the comments made by the respondent, which were the subject of the application, were intended to tilt the outcome in the underlying miscellaneous cause, and also there was a risk of projecting the court in a very unfavorable light in the eyes of the public. And to all intents and purposes, I think the trial judge exceeded the bounds of what's required to safeguard the integrity of the court for purposes of dispensing justice. And that also stems from the fact that very many advocates in this space have framed the actions of the Radical New Bar, they've framed the actions of Aaron Kiza as an issue of indiscipline. And when you frame the conversation around the issues of discipline, it also distorts the depth of what is at risk here. Because a lot of people, and that came out very clearly from the elections we had last year, is that a lot of advocates don't seem to appreciate or are unable to locate themselves in Uganda's civil society landscape. There are still very many individuals who are convinced that members of Ugandan Law Society, and by extension, the society, it should only restrict itself to lobbying for the members' interests and move away from civil society activism. And the danger in that is that a lot of because judges are definitely recruited from the bar. So when members of the bar go to the bench with these ideas, it becomes very difficult for them to understand that as members of the bar, by virtue of that membership, you are an integral part of the civil society landscape of this country. And the principal role of civil society is to demand for accountability and expose government excesses. The judiciary is definitely the weakest arm of government, and the judiciary is not exempt from that scrutiny. The Supreme Court in the case of Attorney General versus Gladys Nachivude Chiseka, that's Constitutional Appeal number 2 of 2016. Judgment in that case was delivered on July 11th, 2018. Was very clear, and it came out to state that that was Justice Professor Lydia. She stated very clearly that judges cannot hide behind judicial independence to avoid broader scrutiny. And as members of civil society, we don't only work with the litigants who are involved in these cases, because ultimately, in the process of performing its duty, the court also shapes the law and the politics of how society is organized, and that also directly feeds into issues of welfare and how we live, representation. And so that entirely means that even individuals who are not directly involved with what's happening in court, they're definitely entitled to understand, have conversations around the things that happen in court. And that's definitely something that the advocates should be in position to do, because there's so many times when we come out and so many times when advocates come out and extend appreciation for the wonderful work that our judicial officers are doing. And the fact that the judicial officers bask in this flattery, it should also go without saying that they should accept the criticism that comes with the kind of work that they are doing. Because if the judiciary being the weakest arm of government, and members of the judiciary don't have a direct mandate through maybe popular election, if they conduct themselves in a way that legitimizes tyranny, that also undermines the legitimacy of the courts in the eyes of the public. Because for a very long time, we've struggled with onboarding, we've struggled with convincing the public to utilize these formal avenues for dispute adjudication, because from the censuses we've had in the past, less than 20% of the Ugandans are actually utilizing these spaces. And if members of the judiciary do not want to listen to this feedback from the service consumers or prospective service consumers, that will definitely aggravate the problems we are currently experiencing. With most of the cases that we've cited so far, the ruling in Sevaduka's contempt proceedings that was delivered on 25th November 2020, and then we also have the decision of the Court of Appeal in Malema Bidis versus AG civil application number 4 of 2022 that was delivered on 19th August 2022. The reason as to why the dates are very important is that all that is outside the decision in Nachivude's case. So in so many ways, it feels like our judicial officers have failed to enforce and follow the guidance offered by the Supreme Court in Nachivude's case, especially in the context of safeguarding the integrity of the judiciary from scrutiny by the litigants and also the third parties involved. So as part of the long-term objective to get around, I would refer to it as an obstruction. It should also start with the members of the bar, it's very important for the members of the bar to go back to the basics and locate themselves in Uganda civil society spaces. Because if you can't locate your place in Uganda civil society, then that also means that you're not in position to utilize the tools at your disposal to push for accountability. That's all I have to say.
Thank you very much. Thank you very much. Thank you very much, Mr. Benon Makumbi. We appreciate that you brought the link between judicial accountability. You're demonstrating that the Supreme Court decisions on judicial accountability do not sit well with this point about contempt of court. Thank you very much. I have seen some questions in the box. I see a consistent theme from Mr. Okello, from Susan Baluka, from Chris Maganga, where they are saying that judicial power is exercised for the people. There is no more royal power. It is the people who are sovereign, and therefore it creates a criminal contempt, therefore conflicts with the whole notion of a sovereign people and civil liberties. Mr. Okuga says we must divorce the ULS from government and make it an independent bar. Thank you very much. We have avoided the debate on the length of the sentences that have been given for contempt in the cases that we've seen. I thought there was a magical factor of 6, but when I've redone my math, I think, which I didn't pass very well at O level, I look for my certificate, but we had 18 months, okay? In the case of Malema Vidizi Chiwanuka, we have 24 months for our president. Then we had 36 months for Ivan Sebaduka. So those are factors of 6. The odd one out is Aaron Kiza, which is 9. We can say it's a factor of half of 6. Yes, and that was by the General Court Martial, and maybe that's why it's out of step. I'm not suggesting that there's any logic to this, but I also noticed that in each case of sentencing, there is no rationale given. There is no explanation of saying, you know, for this reason, I'm going to give this level or that level, etc. But the way the discussion has gone this afternoon is that we shouldn't even be in the territory, that sentences should not be there. The citation for contempt should not be there. Okay, Scandalum Magnatum is dead, and we shouldn't be applying it here. Thank you very much. I have a request to speak from Dennis Kusasira. Is Professor Nshala on the line? Professor Nshala from Tanzania? Professor Rugemeleza Nshala from Tanzania? Okay. Or Dennis Kusasira? Maybe you can contact the Secretariat offline and make your presence known, and they can send you the link directly. Okay. And how do we see a show of hands? How do I see a show of hands if somebody wants to ask for the microphone? Dinosaur things. Yeah, you can ask to unmute. Okay, I see that's what it's saying. You can ask to unmute if you'd like the microphone. Yes, Mr. Muchibi, I see your hand up. I think this is definitely a hand up. Mr. Paul Muchibi. Mr. Paul Muchibi.
Philip. Yes. This is Rugemeleza here.
Okay, Mr. Muchibi, please hold. This is our guest from Tanzania. Professor Nshala, please, you have the floor. I'll give you 10 minutes.
I think I won't. Thank you very much. I won't take those 10 minutes because I think from what I've heard, I think the speakers have covered the subject fairly well, and because given the time that the alert that I was given asking me to speak, basically I'm going to talk about what happened to our former president. For her, she was representing a client in a constitutional case challenging the way our elections are being held in Tanzania, especially having the district executive directors supervising those elections. And the Attorney General raised a number of objections for which she said yes, you might have, those objections might be raised, but we still have our day in court. You might turn us down here, but come 2025, we still come back to court. So the Attorney General found those remarks to be offensive, and that was in a reply to the written submissions. And the judge, while reviewing that, said he was mindful that Fatma Karume had not been given an opportunity to address herself those complaints. So he was going to refer the matter to the Advocates Committee, and for the Advocates Committee to be seized with the matter. But in the meantime, he said he was suspending Fatma Karume from practicing law. And apart from that, the Attorney General was not satisfied. He filed afresh the complaint before the Advocates Committee, and he went to on social media and took all the statements that Fatma Karume had been making against the Attorney General and others. So the Attorney General was basically refiled that complaint, and the Advocates Committee found Fatma Karume to be in contempt. And no, so perhaps I misspoke in terms of saying it was the matter pertaining to the elections, but rather Fatma Karume was challenging the appointment of the Attorney General, of the then Attorney General, that he had not met the required qualifications to be appointed to be the Attorney General. So the Advocates Committee went ahead and disbarred Fatma Karume. So on our part, we took up the case before the Advocates. We appealed to the High Court. The High Court overturned our disbarment, and they still maintained that the matter should be referred to the Advocates Committee. And the original complaint that Attorney General had raised against Fatma Karume should be the one to be adjudicated upon. So can you imagine, that was 2021. To this day, we are still awaiting the day to be heard before the Advocates Committee, because after that judgment, the Attorney General tried to petition to appeal to the Court of Appeal. The applications for leave were turned down. Of course, eventually the law was changed. Now the Attorney General is filing an extension of time to appeal, for which we opposed. We are awaiting the ruling from August of 2024 to this day. It was just an application for extension of time, or it has not been adjudicated. So what is happening in Tanzania, that yes, contempt might be used as one tool of silencing or muzzling advocates, but more importantly, being charged or being that you have committed professional misconduct by uttering words that are unbecoming to an advocate. So there are so many things that they can be gathered from that. So you might have your personal posts, might have your political statements, but all of them can be taken and to be taken that you as an advocate, you had a professional duty to conduct yourself in a manner that befits an advocate. So now in terms of the political speech, what is a political speech? When you are addressing the court? So I find perhaps what our Kenyan colleagues have done in terms of saying that the court should not be immune to criticism, or even if some advocates utter or write words which might appear somehow offensive or unpalatable. I think a reprimand might have been the best option, rather than disbarring advocates or jailing them. So that's what I have from Tanzania. Thank you.
Thank you very, very much, Professor. We appreciate the time that you've taken from your schedule. We know you're traveling on the road. We appreciate the insights you've given us on the Tanzanian case. And it is intriguing that is yet another case of a president of a law society being cited for speech, for what they said during the course of submissions, in which she attacked the Attorney General and said things which got her in trouble. But we are glad that is behind her. I think the lesson that is coming through to us is that in Kenya, in Tanzania, in other countries, these issues were fought long time ago. It seems we're just coming to the party, and we're coming a little late, and maybe with a little more heat, even though our constitution predates that of Kenya and so on. Maybe that's a disadvantage rather than a sign of vintage. Thank you very much. I see comments in the comment box echoing what Ellison said. We are joined at the hip, the bar, and the bench, and that we must coexist. I see Amanya Cohen, a Ugandan advocate practicing in the Republic of Kenya. I see Dorothy Amuron, power. We need to check ourselves in the different positions we occupy as a people in this country if we must serve objectively and for the common good. Well said. Thank you. I saw Mr. Resida's hand up. And apologies if I'm not seeing the hands up, but I saw Mr. Resida's hand up. IT, how do I do that? Can you give him the floor? I intend us to close just on schedule. Who has the microphone? Yes, Mr. Muchibi also, his hand was up. IT? Or is it something that I can do here?
Thank you, Philip. This is Resida.
Okay, thank you.
And thank you to all the presenters. Just a brief comment within the context of a very, very good afternoon that we have had. One is that we must remember as lawyers, because I've heard about Kenya advancement and so on, but we must also remember ourselves. If you look at the Uganda Law Society Act, Section 3, and I not read all of it, we then appreciate that we have a legal basis to play a bigger role than simply appear in court. We have a bigger role to represent and assist members of the public in understanding these matters, in advocating for the rights that we know of, the rights that everyone is talking about. So there's a legal basis for doing that. Two, when it comes to contempt, again, thank you for the distinction between civil and criminal contempt. One of our biggest outcries here is interference of court processes, which undermines independence of the judiciary. In Uganda, all of us have had cries about RDCs who disobey court orders. And we think that is contempt. It's such a big thing for us that we need to start saying, what do we need out of these processes? How should we handle those RDCs? Because that's different from what we are talking about here in terms of these rulings concerning the President of Uganda Law Society. But are there aspects that are still necessary? What should happen? Do we have other laws that would rein in those kind of officials? Indeed, there are other laws that we can look at that hold individual public officers personally liable when they go overboard. And when we look at those laws, do we then still need civil contempt of court? So that's a debate that we need to be having. And my call this afternoon is there are many reforms that are required. We tend to look at reforms in terms of throwing them away to other entities. I'm running for Judicial Service Commission. Yes, I've heard about reforms there, that we should do them there. My view is Uganda Law Society should champion reforms that we need. Thank you very much.
Thank you very much, Mr. Resida. Thank you very much for calling for the reforms. Thank you, and us to champion them. Mr. Muchibi, are you there?
Yes, Philip.
A long time. Yes, you have 2 minutes. Thank you.
Thank you, Philip. Thank you, Philip. Thank you, all the presenters. Very first, I want to bring this discussion in context, rather than from the historical context. Now, there has been an argument
in 2 minutes. In 2 minutes.
Yes. That the bar has been very aggressive. The bar is unapproachable. The bar doesn't want to discuss. We shouldn't forget that the bar has on several occasions been prevented. These issues began way back in 2023, even before Semakade became the president of Uganda Law Society. I would want to give a chronology of events. In 2023, ULS organized an EGM. The Attorney General, then head of the bar, went to court and sued the bar and got an interim order to prevent the EGM. In 2024, again, one of the members of the bar, Brian Iklima, went to court and sued the bar to prevent it from carrying out an EGM. The same judge that has granted the contempt today issued and a temporary injunction order way back in February 2024. That EGM was prevented. Now, again, last year towards the end, December, the same judge issued an injunction preventing the bar from having an extraordinary general meeting. What members of the bar are questioning are very many. This case of 2024 December came around in November, was filed around November, early December. Earlier on, we had Klima, a temporary injunction. In February 2024, the main suit has never been disposed. The case that was filed in November last year, December, is disposed. Even a contempt application that was filed around January this year is disposed. But the one of Brian Klima 2024, the injunction still stands. And these are the questions that are causing a lot of doubt among members of the bar. How can the bar dialogue? How can the bar discuss? Whenever one organizes meetings, you inject them, and it is the bench doing so. The bench needs to check itself, and I think the words of the CJ on the New Year law celebration were clear when he mentioned that we can do without the bar. That is not at all a message you expect from the head of the bench. That is not a reconciliative message. That is not a message that is seeking reconciliation. It is just promoting antagonism. You cannot say you don't need the bar. That is very, very disappointing. And I think if we are talking about a dialogue, let us not play game that the bar doesn't want, the bench wants. When you can tell the bar that we can do without you, that is the most disappointing statement we've heard from the bench. And all these decisions are coming in bad spirit after the CJ telling us this, a few days after, if you don't apologize, something is going to happen. And it has actually done what? Happened. I think both sides need to check themselves. It is not enough to say that the bar is not approaching, the bar doesn't want reconciliation, but your words are also very clear to the bar. You need also to check yourself. And I'm glad to see that some judges that attend the function were equally not happy with the statements. Thank you, Phil. Back to you.
Thank you very much, Mr. Muchibi. So you're underscoring the need for coexistence. We are co-workers in the delivery of justice, and you are also emphasizing that there was some outright aggression from the judiciary, starting from the new lawyer, and as Mr. Ahmed Nasir said, that may have been dog whistling, indicating open season for attack by the judiciary on the bar. That's most unfortunate. Good. So it is now the promise that we promised to stop at 5 o'clock, but perhaps on account that we started a few minutes beyond schedule. Okay, maybe we can take a few more comments. Can I see hands up? There is a suggestion from somebody here. Jasper Mutesasira says we should approach the we should approach the bench and have a football match.
Sorry,
we shall show them why rain comes from the sky.
Philip, you can hear me?
Yes, I can hear you. Yes, who is this, please?
This is Cohen. I've been unmuted.
Go ahead, Mr. Manya. Yes, come in, please. Thank you.
Thank you, Philip. My name is Cohen Amanya, and I'm one of those people who have been banned not to appear in the Supreme Court.
In Kenya?
Yes. One thing that, Philip, we needed to accept, and for me, I'm looking at the process that led to the judgment. One is that before the court made the decision, was there a fair trial? Was there a fair hearing? Can a judge sit in his own case? Those are fundamental questions that go into the core of our constitutional values. And any judge, I mean, we might not agree with what the president is saying, but let us follow the process. There is a process for banishing an advocate. You can lodge a complaint against an advocate. Let us not forget that let those processes be followed. Because at the end of the day, today is the president, tomorrow might be someone else. But if the process is followed, I had my colleague, I think, who talked about purging of the contempt of court. The contempt of court, you cannot purge it when there is already a conviction, because that is the process. You have to be called, you appear before the judge, you are heard, either you mitigate so that you can reduce on the sentence, then after mitigation, it is either you purge, you pardon, you ask for forgiveness, But now, once the judge has gone ahead to make a conviction of 2 years, what else do we have? So let us, members, we might not agree with the president, but let the processes be followed. And let me say this, I was the former in the Council of the Law Society of Kenya. There should never be a day where the bar and the bench is seen to be fighting. Once there is that link that the bar and the bench is fighting, the grass will suffer. And will be the grass, the consumers of the justice. Because at the end of the day, we help each other. We are like twins. Judiciary and the bar are like twins. They cannot coexist when we are not there. So what they need to do is to make sure that we coexist with them. Otherwise, if they start following the process, then it will come to haunt them. Then the judges don't feel that they are on the bench. One day they will retire and come back to the bench. And they will find the young lawyers who have followed the same decisions. And I will quote this. When the Parliament of Uganda was passing what we call the Order Management Bill, the persons who were there pushing for it are the same persons who face the law. So let us be mindful that we protect the law. And I can say this, I love NRM, I love my party, I love everyone, but let the judiciary not be in that habit of thinking they are above the law. As I wind up, please, members, it's the time for us as members of the Law Society to rethink about the Judicial Service Commission. Because all these complaints that members file at the Judicial Service Commission, all of them, if you don't have a vibrant, a sober person who is representing our views, we will suffer. It's the high time. The question is, why is it that all of these issues are coming up for one judge? Why are they that all of these issues are coming up when they're radical? There is the members are going to decide on who should represent the JC. All of those issues, because if we raise a complaint against the judge, it goes to the JC. The JC, if you don't have members to push your agenda, we will be useless. So it's the time, let us see all the candidates and see who will push our agenda. Otherwise, if the processes are not followed, even it's high time we reconsider amending the law. Look at the amendment of the law. The Uganda law, and then I will tell these members, even the members of the Law Society who are here, that there is a need to amend the Advocates Act. We cannot have one entity called the Law Council dealing with everything. It deals with advocates, deals with universities, deals with everything. So even if right now you want to make a complaint, you make it to the Law Council against an advocate. What the hell is that? So let us, we might, and Mr. Philip, let me wind up. Members, also let us respect the bar. But let also the bar, when we respect them, let them also remember that we are part of them. They will retire, they can make decisions when they are there, but a day will come when they will retire and come back to the bar. If they don't enhance the bar, so the bar becomes strong. When they are faced with challenges like the Chisache of these days when she's running away, I mean, she will be, it's the bar that will save her. It's the bar that will save. It's the Uganda Law Society that will save them. Thank you very much.
Thank you very much. Mr. Manya is a Ugandan lawyer working in Kenya in the chambers of Ahmed Nasir. Thank you very much for that sterling contribution. We are twins. We must work together. We must have mutual respect. You've called for a careful selection of a representative for the Judicial Service Commission because the reform that is required in this area is central to everything that we are trying to do. I would like to dedicate the... Yes.
Dennis here. All along I was trying to unmute myself, but
I see.
I've just succeeded. Thank you for the wonderful discussion. My name is Dennis Kusasira. I'm an advocate. I think, yes, I will do in 2 minutes. So what I understand, Philip, this offense of scandalizing the court has been abolished in some democratic countries. And I think the one that comes close to memory is the UK that has abolished this offense. But even in those countries where it persists, it is used sparingly because it's now known that the freedom of expression, freedom of speech, and judicial accountability are ranked above the personal feelings of judges. But now that we have it here, I think the critical point we have to be discussing is these procedures that are being taken in these cases, starting from the Sebaduka one, are they constitutionally permissible? Where the same court, which has been angered or purportedly insulted by a person, be the one to try to actually adjudicate and sentence? I think it's wrong, and my views were well expressed on my X handle in the comment to this case where our president was sentenced to 2 years. There is a decision that I would like members to read. The decision of, I know these names are very, very difficult, but it's a decision of the European Court of Human Rights. The decision of Kiapranu versus Cyprus. I'll send you, Philip, the case so that you can share it. That case dealt with contempt in the face of the court. And also I want members to distinguish between these two. Contempt in the face of the court is contempt which is committed while in the court proceedings. Someone, utters words or conducts themselves in such a way that undermines the authority of the court and its independence. At common law, the practice was to summarily deal with the contemner and sentence them there and then. But this has changed, as you'll see in that case of the Cyprus case that I will share. The courts are now saying a person who is accused of contempt is also entitled to the same procedural guarantees as any other person. And our Article 28 clearly states that. And in that case, the European Court of Human Rights observed that the language used by the judge in the decision clearly shows that he had been deeply insulted, and they didn't think that the person, the appellant, had received a fair trial. So I think the Sebaduka case, it is a case that was proceeded wrongly, and so was the Mabilizi case, and so is this one of our president. The other aspect I wanted to comment on is the penalty. Again, of course, if the penalty is handed down by a judge who is angry, who is annoyed because of the comments, what do you expect? Unless that judge is not human. But if you are human and you are the one who has been abused and they have asked you, in Uganda we normally say omugabite yesera, so you just met out the hardest of sentences because you are the one who is giving and you are the one who is now deciding. So me, I found it very strange, and I think the way forward would be, I don't agree that the person would be precluded from approaching the higher courts because they have not purged themselves of the contempt. Purge what? There was even no such an order saying go and purge yourself, but purge what? The whole proceedings that decided that this was contemptuous were unconstitutional, without really going into the merits of whether they were or not. So there's nothing to purge oneself of. So me, I think that it's important to approach the higher courts. One of the points that we want to test out probably is suspension of this sentence, because I don't know whether the stay helps us, but the suspension of this sentence, as we have seen in other contempt proceedings, by the way, I've filed contempt proceedings in courts, in civil courts, and what I have gotten always is a suspended sentence. I have not gotten an imprisonment so far. They are always suspending, and I think even if this judge who sat in their own cause had found that these were contemptuous comments, he should have given a suspended sentence and then give the person affected a chance to reflect and probably reform. But of course, I think that we have a problem that the judge has also now gone to the Court of Appeal, and Justice Wangutusi talked in one case about what we call the canteen banter. So you don't know whether if you go there also, you're not going to have that canteen banter effect of the judge sitting on a canteen tea or coffee, or I mean cup of coffee or cup of tea, and say, I was really angry by that man, angered by that man, and that is the sentence I gave. Please do not set it aside. But also you have the fact that the Chief Justice has already pronounced himself and demanded an apology. So what does that mean for a person who has been convicted or sentenced, but the head of the judiciary thinks they should have apologized before the decision is made? So these are really serious issues that we need to consider as we ponder on what remedy our president can take. But I think it's good to try out to go to the higher court. And first for me on my agenda would be to apply to stay or suspend. I would go for both. Stay or suspend this sentence and cite the fact that there was a violation of the principle of no one can be a judge in their own cause. And also, I read the decision and I don't think there was sufficient evidence that service was effectively done. If it's done on an advocate in a case which has not been having continuing instructions, I do not think you can say that was proper service. I saw a claim that there was a service on WhatsApp, but I didn't see the judge confirming whether he read and saw that there were blue ticks and there was proof that service had been done. So I also think that there was condemning someone unheard, which also is a violation of the very right of fair hearing that was exercised first in the Garden of Eden. Everybody needs to be heard, even the snake, which is considered to be very, problematic and venomous, was heard. God asked questions to all. If Adam, the snake, if the snake was heard, what is this that our president did that required someone proceeding without hearing them? So I think the discussion continues, but in my view, the bigger point is we need to define the rules. When there is contempt, if at all this archaic offense or whatever you want to call it is to be maintained, what are the parameters? Should the judge who has been insulted, as they say, be the one to decide? And the other thing is to look at the decision of Justice Mulenga on freedom of speech, that if you want to limit freedom of speech, then the limitation must be set out in a law. So which law now prescribes the limits that take us beyond what is the actual, expression of opinion versus contempt? And without that, I think that we don't have any limitation under Article 44. So we can speak. And the courts outside, they have said that, by the way, contempt of court should be distinguished from expressions that are shocking, annoying, and insult can be dealt with under other laws, not contempt, because contempt is for protecting the authority of the court. If you are insulted, it's not that you don't have a remedy. I think people even misunderstand this. They think that when we say people have a right to speak, people have a right to express opinions. If they express opinions and those opinions are defamatory, and those opinions, in your view, are insulting, first of all, insulting may not necessarily be defamatory. But if you think they are defamatory, then there are other remedies, rather than weaponizing the court against advocates, the courts against fair commentators. I think that's all I can say for now. Thank you, Philip, for this.
Thank you very much, Dr. Dennis Kusasira. And you know why I call you doctor. That has been incisive. You have put us on a very high plane, ending with the remedies that we should consider as a society for our president, because this is not his issue, his fight. This is for all of us. This is not just for the law society, but it is also for the judiciary, and it is also in that respect for the country. Mr. Nyakojo, thank you very much for your comment about elephants fighting and the grass suffering. Pamela, yes, I think you are concurring fully with Dr. Kusasira. same as Pamela Abio, that the snake was hard. I have to read my Bible again. I think I must have missed that. Okay, so it's now 5:15, and this was supposed to be a 2-hour session. The Law Society has indicated that they will be open to having a second round of this so that we get to the bottom of things. And my proposal at this point is to thank you all. I think we've made more than 500, 600 people. Thank you very much for our senior counsel, Mr. Ahmed Nasir, senior counsel, Nelson Havi, senior counsel, and Professor Nshala. The solidarity from Kenya and Tanzania in joining us on this call, Mr. Amanya as well, and other people who we may not be able to recognize on the call. Thank you, all of you who are sitting there in the Uganda Law Society offices. I hope they do give you a cup of tea. And thank all of you members who've attended online. Please, let's look forward to the next session. We try and bridge the gap between the bar and the bench. We try and resolve the issue so that an effective remedy is legal remedy is found to address this issue. Thank you all. Thank you very much, and have a lovely evening.
Thank you, Philip.